Welcome back, everybody, to Contract Law. This lesson is going to start talking about the next major topic within the subject of contract law. We've spent quite a lot of time talking about the creation of contracts, talking about the various requirements that are necessary for the creation of a contract. We talked about the creation through an agreement, which is represented as offering versus accepting. We then talked about an intention to create legal relations. And then finally, we focused on the question of consideration and promissory estoppel. This lesson is going to start talking about terms of a contract, the idea of contractual terms and their importance within the broader conversation that we have about contract law. So this is the next major topic within our series on the law of contracts. And it is going to focus on the actual specific terms of a contract, the kinds of things that are actually written in the contract. So we're moving beyond their creation and whether or not contracts even exist in certain circumstances owing to various different factors. And we're going to start to talk about what actually exists in contracts that we know exist. So we know that the contract exists. We have solved the question as to whether or not there is a created contract here, because we've looked at all of the conditions required for the creation of a contract. Now we're looking at what the contract itself actually says. So this refers to not only the content in terms of specific contractual terms, contractual provisions, but also in terms of the structure of a contract. The vast majority of terms within a contract are actually expressly stated in the contract. So if a contract is established, a written contract that requires the performance of a particular action, well then, if that is expressly stated in the contract, that just means that we see it written down as a term of a contract. Clause 3 tells us that we have to do this performance in order to fulfill our obligations under a contract, for example. There may also, however, be terms which are implied into the contract, which don't necessarily have their own explicit clause, which requires you to actually be able to just read it and see what is to be done, but more so are by the nature of the contract or by the nature of the obligation implied into the agreement. It may also be the case that, while in a period of negotiation for a contract, a number of things which were stated could be potentially terms that end up being incorporated into the contract, but also may not be terms, and so are not incorporated sufficiently into the contract either. So it is important, as a result of all of this, to begin talking about the pre-contract stage, i.e. the negotiation stage, before the contract is actually formally agreed upon, to see the kind of things that could be negotiated into a contract. And the first thing I want to just make a reference to here is this idea of puffs. Puffs are the weakest form of statements which are made in the negotiation / the sort of pre-contract stage of an agreement. And what they essentially mean is they have no fulfillment if they turn out to be false, and there is no liability incurred to an individual charged with making it. They are just simple statements that are made that essentially have very little meaning, okay? And so you cannot rely on such statements to enforce contractual obligations against individuals. These are most often found, in fact, in advertising circumstances to boast at the quality or the performance of a good or service, but do not carry with them any kind of legal obligation. For example, when Red Bull sell you their energy drinks, they will say Red Bull gives you wings. Now, you could not, as a result of reading that slogan, that advertising slogan, sue Red Bull on the basis that they didn't give you wings, because that is not what it's not a term of a contract. It is simply a puff, a weak form of statement, which is made in often the pre-contract stage. So yeah, it doesn't actually give you wings. In fact, in my opinion, they're not very nice, Red Bulls. So next we have representations. A representation is a slightly stronger form of statement, and a representation is defined as a statement which is made, which is not and does not form part of a contract itself, but instead will induce an individual to enter into a contract. So we delineate this from, if we go back to the previous example of Red Bull gives you wings, this cannot be a representation, because the concept that Red Bull gives you wings probably did not induce people into going into and entering into a contract. They're a little bit more serious if they are false or if they are not fulfilled in terms of their obligations. If a representation is made about a product which turns out to be false, then people have entered into the contract on the false premises. So essentially, for example, you could make a representation about the quality of a product, and so if that and then if obviously taken from a positive point of view, if it is therefore concluded that the person is going to create a contract or enter into a contract with you on the basis of that quality assessment, and then it turns out that the quality is actually not what the assessment said it was, then this again would represent quite a serious representation, or at least an invalid representation, which, because of the idea here, is that fundamentally, if you are falling into a contract because of a thing that was said, a representation that was made, and then it turns out that representation is false, then you have entered into a contract under false pretenses. And so the most important liability will be for misrepresentation in this area of the law, something we'll get to in future lessons' time. Finally, then, we can think about terms. Terms are simply part of the contract itself. They're not simple, catchy slogans which have very little, if any, value at all in contract law. They're not representations. They don't induce a person to enter into a contract. They are the terms of the contract. An inducement has already been made. People have already entered into the contract, or at least have a desire to enter into the contract. And now we have the inducement into the contract. It will often be expressly stated as a clause within a contract, a term would be, and will make a pledge to do something or perform some kind of undertaking. Where a term is reneged upon, where terms are not followed, okay, the injured party has the opportunity to sue, because at this point they've breached their contract. If you breach the terms, if you fail to perform your obligations under a term, then you can be sued for breach. Now, whether or not that person, the claimant, would be successful in that case would depend, of course, on whether or not you had a valid reason to breach your contractual obligation, in which case there might be a reduction in damages. But for now, just note that a term would actually, if reneged upon, cause the opportunity for an individual to breach the contract. In this lesson, what I want to do is talk about the incorporation of contractual terms. What does this mean? How do I explain it? And what can we glean from this particular area of the law? All of which are questions we're going to explore in this lesson. The previous lesson took an introduction to contractual terms. We made the distinction between puffs, representations, and terms. The idea here of a puff was something of for the most part, we could make it, it was akin to, shall we say, a marketing slogan, some kind of thing that doesn't really have any kind of legal obligation attached to it, owing to the fact that it is just simply a statement of advertising, if you will. So the advert that we used as an example of this was Red Bull gives you wings. Now, of course, Red Bull doesn't actually give you wings. You couldn't sue Red Bull on the basis that you drank one of their energy drinks and that I didn't get given wings, therefore there's a breach of contract here. That's not how it would work. Representations, we noted, were a little bit more serious. They were statements or they were information, shall we say, given about a particular product or a particular service that induces a person to contract. So if I was told about the quality of a product, and I was told this, that, and the other about the quality of this product, and that information causes me to want to buy the product and enter into a contract for the purchase of the product, and then it turns out that representation was false. It was not actually what the representation said it was. Then this would represent something of me being induced into a contract under false pretenses. And so the result of this is often likely to be able to get some kind of remedy in the basis of misrepresentation. But it is interesting here that representations are a little bit more serious than puffs. The final of which we were talking about was this idea of terms, the terms of a contract. The terms of a contract are the specific things that are in the contract itself, either expressly stated in a clause or implied through the contract itself. And these, of course, if you were to breach a term of a contract, the person would actually be able to sue for breach of contract. This lesson is going to talk about how one is able to determine which pre-contractual statements are kept as representations and puffs and which are incorporated into the terms of the contract itself. So if we go through the arduous process of a potentially lengthy negotiation between different parties in relation to contracts, and we find ourselves in the position where we have made lots of different statements, we've made lots of different representations, some of which may or may not enter into the contract itself, we are now asking the question, well, how do we determine? How can I determine which pre-contractual statements are kept as representations and which ones are not? Well, the incorporation of terms is an interesting element within the law of contracts. When it comes to which statements are incorporated into the terms of the contracts, the courts will often look at a number of considerations, a great many different considerations. For example, what are the intentions of the parties in the contract in the first place? That's an important question that needs to be asked. What did the people who were creating the contract intend? If there was clearly an intention that something be incorporated into the contract, then arguing that it should merely stay as a representation is probably not going to slide very, very easily. Now, given the difficulty examining the intention of parties, as well as all the other considerations that need to be ascertained, the courts have been able to develop a number of tests and procedures for examining the incorporation of terms into a contract. And I will refer us firstly to the case from 1976 of J. Evans and Son Portsmouth Limited. In this case, an agreement had been made between the parties for the shipping of products into the United Kingdom. The contract itself was in writing, and there was a clause within the contract which gave the transporters a certain amount of discretion in respect of, quote, the procedure to be followed in the handling and transportation of the goods. So the handling and transportation of the goods was something that the people who were actually doing the transporting had a certain amount of discretion over. They weren't going to control every single element of their job. And this was in the contract. This was a clause that was in the contract. In addition to this term that was clearly stated in writing, the parties had also come to an oral agreement that they wanted their product to be transported below deck. This was something, however, that did not happen. So you sort of have a bit of a clashing of terms, if you will. Not necessarily a complete contradiction of terms. They still had discretion to in terms of the procedure and the handling of transportation. But they said, "Can we have our goods transported below deck, please?" And this was an agreement that they actually said yes to. We will transport your goods below deck. Because the items shipped were above deck, the container would fall off and be lost overboard. Of course, not very good. The claimants then would sue on the basis that the defendants had breached their contract in terms of carriage. So this is quite interesting. They didn't just sue on the basis that they lost the goods themselves, which they may or may not have had a successful claim in, but they sued on the specific point that they had breached a term of the contract through this little oral agreement that was had. Now, the question was this oral agreement incorporated into the contract such that it represented a term that was as valid and as gold standard as the term that was actually in the contract, which gave the procedure allowed the procedure to be followed in the handling and transportation of the goods in terms of the discretion that they gave to the defendants. It was held that the oral agreement which was made between the parties, despite not being in writing expressly, was incorporated into the terms of the contract. The courts took an approach of examining the holistic set of circumstances as well as the evidence, rather than just looking at what was literally written down. They looked at the entire circumstances, all of the situation, everything that was being spoken about, and they came to the conclusion that yes, it was clearly the intention of the parties to have the goods below deck. It was clearly agreed upon that this would be the case, something they failed to do, and the result of which led to a breach of contract. When we think about written terms, for the most part, when we are looking at what is incorporated into a contract, the strongest indication that something has been made into a contract is if it is actually written in the contract. That is almost that is a silver bullet in terms of argument that something is being put into a contract if it actually has been put into the contract. It is almost tautological. And so this is something that I'm not going to spend much time thinking about for the most part, given the fact that when we have written terms, they're incorporated into the contract. It is often either terms that have been put in writing that are separate to a contract, or things like oral agreements that need to be incorporated into a contract as well as implied terms which are implied into the contract, all of which we'll get to in future lessons' time. Welcome back to another lesson in the law of contracts. In this lesson, what we're going to do is talk about the parol evidence rule. And this is just something of a minor point that we need to make reference to when examining contractual terms. We'll talk about what the parol evidence rule is, the general principle therein, and then talk about a couple of exceptions to this principle. So, essentially, what the parol evidence rule does is it provides the courts with an indication as to the admissibility of evidence which is not incorporated into the written contract itself. So when you're examining as a court the various different terms of a contract, the question that you have to think about is, if there are things and there are points and there are things that may or may not be incorporated into the contract itself, to what extent is evidence that isn't in the contract admissible to the terms of the contract? Well, essentially, a contract which is written down is presumed to be all-encompassing, and anything which is not in the contract itself is considered to have not been an intended term, and so as a result of which it would not be valid. So, obviously, there's a little bit of an exception, a little bit of difference when we're talking about oral agreements and agreements which are not written down. But essentially, the point that it is trying to make here is that there is a basic presumption of contracts that where they are written down, the writing that exists is the all-encompassing beginning and the end of the contract, and that there are no other terms that exist outside of this contract. This obviously is useful for courts to basically draw the line at what may or may not be included into a contract. If this rule didn't exist, if it was just presumed that anything could, even if it isn't written down, could be still part of the contract, then parties will continue to make various additional claims as to what may or may not be in their contract, which goes beyond the scope of what is written down, which of course would eventually lead to a bit of lunacy. So, the parol evidence rule essentially tells us that when it comes to contractual disputes, something known as parol evidence, evidence which is not incorporated into the contract, is presumed to be and is deemed to be inadmissible. And so there are notable exceptions, which includes the previously examined cases from previous lessons, but it also, like I said, will include other exceptions too. And I just want to talk a little bit about the J. Evans and Sons Portsmouth case from 1976. In this case, an agreement was made between the parties for the shipping of products into the United Kingdom. A contract in writing and a clause gave the transporters a certain amount of discretion in respect of, quote, the procedure to be followed in the handling and transportation of the goods. So an agreement was made for the shipping of these products, and the handlers, the people who were actually doing the shipping themselves, had a bit of discretion in relation to the procedure to be followed in the handling of transportation. So it wasn't determined and specifically cited where and how these products would be shipped, but just that they would be shipped. In addition to the term that was in writing here, the parties had actually come to an oral agreement that they had wanted their products to be transported below deck, just a specific requirement, something which actually did not happen in the conduct of the shipping. They failed to follow along with this particular request. And because the items were shipped above deck, the container actually would fall overboard and be lost, obviously causing quite a lot of financial loss. The claimants would then sue on the basis that the defendants had breached their contracts in terms of carriage. So their breach of contract came from the oral agreement. It came from their alleged breach of the oral agreement because they wanted it to be shipped and transported below deck, but it had not been shipped and transported below deck. And of course, if it had been shipped below deck, they probably wouldn't have gone overboard. It was held that the oral agreement which was made between the parties, despite actually not being made in writing, was in fact incorporated into the terms of the contract, representing something of an exception to the parole evidence rule. Because if you were to just take the parole evidence rule at its face, you would come to the conclusion that if this oral agreement is not part of the contract, then it is deemed to be inadmissible. Well, what the courts did was, instead of a very strict application of the parole evidence rule, they took an holistic examination. They examined a set of holistic circumstances and evidence rather than just which was written down in the terms. And so from that conclusion, they came to the view that the parole evidence rule was not really applicable, or this represented something of an exception to said rule. Other exceptions include various different instances where the parole evidence, generally evidence which is not incorporated into the contract, may be admissible for contributing to evidential claims. Parole evidence, for example, can be used for equitable purposes. So, for example, where there is not an accurate representation of an agreement, there is the equitable remedy of rectification. According to the case of Hutton and Warren from 1836, evidence which is not incorporated into the contract can be admissible, quote, to annex incidences to written contracts, in matters which, with respect to which they are silent. What the point here is that essentially, if you have a contract that is all written down and there is some parole evidence, there is evidence that exists outside of the contract, and this parole evidence actually seeks to and exists and it actually contributes to an area of the contract to which there is silence, to which there is no actual writing and no actual conduct for how that should act, then the parole evidence could actually be used to basically fill in the gaps to find and to essentially annex incidents to written contracts in matters with respect to which there is silence. It could also be admissible for the determination of a time period of a contract. Sometimes the time period is not specifically cited in a contractual arrangement, and so parole evidence may be determinative in that regard as well. In continuation of our analysis of contractual terms, what I want to do here is start talking about the various types of terms that may exist in a contract. And we're going to begin with arguably the strongest of the contractual terms, which are, of course, conditions. We'll spend a little bit of time about the nature of conditions in this video before we start looking at other parts of a contract, things like warranties, for example. And we will examine the nature of the binding nature of conditions, the authority that they are attaching to, as well as some other subsidiary factors therein. So, the previous lesson, what we did was spend a little bit of time talking about the approaches that are taken when it comes to the incorporation of terms into a contract. And this lesson is going to start to look at those terms themselves. We will start talking about the first type of contractual terms that are incorporated into a contract. These contractual terms, of course, being conditions. So, in terms of types of contractual terms, when we look at the content of a contract specifically, we can broadly categorize the terms that exist into three main distinctions. We have conditions, we have warranties, and we have what are known as innominate terms. For the most part, things are conditions or warranties. Innominate terms are a little bit less utilized, or not often there as much. And generally speaking, of course, because we're not now talking about the creation of contracts, which was topic 1, we're talking about the actual content of a contract itself. We can generally delineate and define them into these three categories. You could theoretically take any contract and you could have 3 different highlighters, and you could highlight which are the conditions, which are the warranties, and which are the innominate terms. And then there are a couple of other little pieces that may exist as well. This lesson is going to focus on the first of these, and then the next lesson will focus on the concept of warranties, and then the lesson after that will focus on the concept of innominate terms. Conditions will specify the most important part of the contract itself. Now, they are essentially what Goto considered to be the root of the contract. Contracts very often have a number of very key goals that they are trying to achieve, very key conditions that are essentially the most important part of the contractual arrangement, and then from there you have you may have other conditions, which are also very important, but then you will also have other terms like warranties and innominate terms. Given that conditions are essentially the most important part of a contract, the most important part at least of the terms of a contract, and in addition to the fact that they represent something of the root of the contract itself, the heart, if you will, the purpose of the contract itself, where there is a breach of a condition, this will often give rise to the most important range of remedies which are available to the aggrieved party. So one of the things that's very important when we talk about contractual terms is being able to identify which of the terms are conditions, warranties, or innominate, because that will inform the extent to which we have different remedies available. Conditions will most often always have the strongest remedies available for their breach, because it would represent a breach of the most fundamental part of the contract itself. One such example of this comes from the 1876 case of Poussard and Spires and Pond. This case exemplifies, in fact, the issue of breach in context of a contractual condition, because what this involved was an actress who had a contract to lead in an operetta. And so this really strikes to the heart of really what a condition is, what a warranty is, and the distinction between the two, and why this distinction is so important for when we actually get to looking at breaches of contracts. Before the first performances could be done by her, she had to cancel on the basis that she had fallen ill. The defendants then sought to replace her with somebody else who was able to do the performances on the nights that she could not. Now, she would then sue the people who were in charge of the operetta, the people who owned the theatre or whatever it was. She would then sue those people for a breach of contract. And it was held that she could not make a valid claim, since her performing in the operetta, her performance was so central to the purpose of the contract itself. It represented a root to the contract, a root of the contract, therefore representing a condition. It was therefore the case that she had breached the contract, in fact, by failing to fulfill her duty to perform on those nights. So, in fact, rather than the operetta failing to uphold their end of the contractual arrangements and breaching their contract, it was in fact the singer. It was in fact the person who had the lead in the operetta who was performing that was doing the performance. They had in fact breached the contract by failing to do the performance on the night that she was ill. We will get to a different case that is similar in a different lesson, in the next lesson, I believe, or the lesson after, which involves a very similar set of circumstances, but whereas in this case, you see that the breach comes as a result of her failing to perform in the operetta, there was the allegation that the breach came in regard to their failure to actually turn up for rehearsals. And so the question there was whether or not rehearsals actually was something that struck to the heart of the contract and therefore represented a condition in the same way that a performance did. And that's something that we'll get to in the next lesson. It's very useful in the law of contracts, in fact, because there are lots of cases where there are a very similar set of circumstances, but where there are slight differences that clearly exemplify the difference between a term and a warranty, or the difference between offer and acceptance, or the difference between the postal rule or consideration, or all these different kinds of things. So these are really useful illustrations of how contracts actually work on a day-to-day basis. In the previous lesson, what we did was spend a little bit of time talking about conditions as a type of term within a contractual arrangement. We talked about what a condition is, and we talked about how conditions really strike to the root of a contract. They really strike at the heart of a contractual agreement. And we noted that this is reflective in the ways in which this would then relate to the breach of a condition, and how this would change the scope of remedies that may be available in those circumstances. This lesson is going to talk about warranties. Warranties being a different type of term that exists in a contract, and what they mean, how they operate, and how we can determine what a warranty may be. So we noted in the previous lesson that conditions are fundamentally the main and most fundamental contractual terms available to the parties. The next type of terms that are express terms, at least within a contract, are warranties. Of course, there is this existence of what are known as implied terms, which we will get to in future lessons. So the key element of the condition within the contract is that a condition speaks to the heart of the contract itself. It is the main thing that the contract is established for, and it is the main thing that the contract exists to achieve. If we remember back to the previous lesson, the Poussard and Spires case, the key element, which was identified to be a condition within the contract, was that the singer in question is able to perform at the operetta. This was a contract between the operetta and the singer for the singer to perform. So the purpose of the contract is for the singer to perform for some payment. And so the heart of the contract, the fundamental part of the contract, is actually the idea of them singing, the contractual obligation for them to be singing. This is because without this action on the part of the claimant, i.e. the contract itself, the singing itself, then the contract would be rendered effectively useless. So we can essentially make a distinction, therefore, between a condition on the one hand and a warranty on the other, given that a condition pertains to the ability for a contract to continue. And so, as a result of this, you might have lots of different terms in a contract. Okay, all of these different terms and conditions do all different kinds of things. Okay, conditions are required to allow for the contract to continue, and then warranties may or may not be breached, and there may or may not be any kind of remedy in place, but that there could still be the continuation of the contract if this was to happen. And so this gives us a very interesting illustration of what a warranty is. In some cases, contracts will have terms which are somewhat subordinate to that of the key conditions, to that of the main element of the contract itself. These are terms which will still require performance, and if they are not performed, for example, there could still be the attachment of a remedy, but they are not terms which necessarily destroy the whole purpose of the contract. Let's remember then back to the case of Poussard and Spires, and let's say we have a contract, therefore, between the singer and the operetta for the singer to sing at the operetta. Let's assume that within this contract there is also a term that says that the singer has to sing wearing a purple hat. They should sing wearing a purple hat. The contract itself is a contract for them to perform at the operetta, and there is another condition here that says that the singer has to really perform we want the singer to perform in a purple hat. If the singer was not ill, as is the case in this particular illustration, but in fact was able to sing, but didn't sing in a purple hat, this is still a breach, technically, of the contract. There was still an obligation to perform that part of the contract, but it doesn't render the contract meaningless. The contract can still continue because they can still go and perform and do the singing. So whereas the condition is the part of the contract that says that the singer has to sing at the operetta, the warranties might be the condition, or the term, should I say, that they do it in a purple hat. Because if they fail to do this, there could still be a remedy. Maybe there might be a financial penalty for not performing in a purple hat, but the terms themselves do not destroy the whole purpose of the contract. So if a warranty is breached, it is likely that this would not break the contract itself. It is for this reason that the remedy available to the injured party will be lesser than if it was with a breach compared to lesser with the breach of a warranty, compared to that of a breach of a condition. If a breach of a condition takes place, then this strikes to the heart of the contract. Likely, the contract cannot be performed. It cannot continue, and likely, therefore, there will be quite a significant remedy. With a breach of warranty, there may only be damages available, rather than a discharge of one's obligations. Remember, owing to the principle of consideration, when a contract exists, there is obviously requirements for both parties to actually do something in order for that contract to actually be valid. So, if a condition is breached by one party, then you might be discharged of your obligations as the other party to actually perform or do whatever it is that you were required to do as part of your consideration. But if it is a warranty, then there may only be damages available, and you might still have to continue with your obligations. So the case of Bettini and Guy from 1876 gives us a very strikingly similar set of circumstances of Poussard and Spires. In fact, in both of these cases, we can compare to show the different distinction between a condition and a warranty. It involved a singer who was under contract to perform in a number of different theatres. Just like with the previous case, he was in fact replaced and sued for breach of contract. But this wasn't because she wasn't because she failed to turn up to the performance because she was ill, like in the case of Poussard and Spires, but rather she failed to turn up to the rehearsals, something that was also stipulated in the contract. So the contract was for you to perform at an opera, or perform in a theatre, to do some kind of theatre performance, okay? And there was also another term in the contract that says you also have to turn up for rehearsals. They failed to turn up for rehearsals, and so they were replaced, and there was a suing for breach of contract, similar to that of Poussard and Spires. Unlike the previous case, however, the claimant here was successful. This was because the term which stipulated that they go to rehearsals was not considered to be a condition, but instead it was considered a warranty. Okay, so therefore, if it was a condition, it would have meant that there was a breach of contract and there would have been a breaking of the contractual arrangement. Instead, it was a warranty. The defendants would have been able to sue for damages for the breach of warranty. They may have been able to sue for some kind of compensation for failing to turn up to rehearsals. But because it was a warranty and it wasn't a condition, it wasn't something that struck at the heart of the contract, they were not entitled to repudiate and terminate the contract in its entirety. In this lesson, what I want to do is talk about the concept of innominate terms within a contract. Now, these are a very specific and different kind of contractual term, or at least the way that they are viewed is very different to the ordinary conception of a condition and a warranty. Namely, it's an approach that the courts may take in making a determination as to the appropriateness of what the term might be. So this actually is our final lesson, looking at the different kinds of express terms one may be able to find in a contract. The first of these, of course, is conditions. Then we've also looked at the idea of warranties. Now we're going to look at the issue of innominate terms. These are an interesting approach, which again, the courts have adopted this approach in certain circumstances in making determinations as to the contractual terms themselves. So in making determinations, pardon the pun, the previous two lessons looked at the two main ways in which a court would determine different contractual terms. And we've noted that the reason why this is very, very important is because the type of contractual term that we are talking about will depend on the type of remedy that an aggrieved party may have if that term is breached. In some circumstances, where we are talking about conditions, it is likely or more than likely that there would be the ability for discharge of their obligations under the contract. The contract essentially ceases to exist, it becomes frustrated, becomes breached, essentially simply, etc., etc., so I say. Whereas with a warranty, there may only be an available remedy of damages, which is then therefore requires you to still maintain your obligations under that contract in performance of your consideration. If the terms themselves, like I said, speak to the heart of the contract themselves, there will be conditions, and the breach of those terms may likely involve the ending of the contract. If the terms are more subsidiary to the agreement and do not necessarily lead to the destruction of the contract if they were to be breached, then we suggest that these are warranties, and that their remedies that are in place are a little bit lesser. The distinction here is important since it would inform essentially the type of remedy that are available to an injured party. But how do courts conclude which terms are which? How do you come to a conclusion on that basis? Well, we can think about the idea of innominate terms. Sometimes a court will not make a decision as to which terms are which, essentially, by examining the terms themselves. We don't necessarily look to the terms themselves, but rather they might say, well, what would the impact be if this term was breached? And what would this have on what impact would this have on the injured parties if this term was breached? And then from there we can potentially make a conclusion as to the ability for us to determine whether or not a term is a condition or is a warranty. So instead of reading the terms themselves, they shall wait and look at the effect of the breach of said terms. Only then can a determination be made on the effective remedy in the classification. The concept of innominate terms was established in the case of Hong Kong First Shipping Corporation from 1962. And in this case, we see an attempted repudiation of a term. The claimants would then bring a claim for wrongful repudiation on the basis that the term was in fact a warranty and not a condition. So we have a confusion as to the extent to which something is a warranty or whether or not something is a condition. The contract itself was for the charter of a vessel and a period of 2 years. And the term within the contract stipulated that the vessel was to be, quote, in every way fitted for ordinary cargo service. So it's a term that requires a certain level of quality or a certain adherence to quality for the type of vessel that we're talking about. This was sometimes known as a standard seaworthiness clause within basic maritime shipping law. So fundamentally, a lot of maritime shipping contracts that exist will often stipulate that the ship in question that is going to be doing the chartered vessel in question that is going to be essentially transporting the cargo should be at least seaworthy. It should be able to actually allow for and be able to do ordinary cargo service, essentially stipulating that the vessel was actually seaworthy. In reality, for this particular case, the ship was very poorly fitted, and the crew were very, very incompetent, all of which led to a requirement that the ship be repaired and fitted with a better crew, something which took an extra 18 months. It was held by the courts that the seaworthiness clause was actually an innominate term. So in addition to this, the courts held that it was not breached to the efficient extent to validate the termination of the charter party, but it was noted that it was an innominate term. It would be something that is determinate on the basis of the breach itself rather than being able to be determined on the character from looking at it on its face. Quote, they say, there are many contractual undertakings of a more complex character which cannot be characterized as being conditions or warranties. And this is really where we see the introduction of this understanding of the innominate term. The innominate term being one that could theoretically be either, but depending on the breach of the term itself would determine whether or not there could be the effective repudiation of a contract, the termination of the charter party, or even just smaller damages and smaller remedies, which would therefore signify that it could potentially be a warranty.